So I have read your motion, Mr. Cox. Thank you. Is there anything you want to add, highlight, accentuate? I will turn to you, and then I'll tell you what I know, and then we'll hear from Mr. Johnson.
All right, thank you, Your Honor. Your Honor, my job was incredibly easy in this case because I simply was a pencil pusher, to be quite honest, Your Honor. These folks came together with a consent judgment of divorce, not guided by me in any way, shape, or form. We didn't even go to mediation, Your Honor. It was just these two adults coming together on every issue: custody, parenting time, child support, including real estate, one of the nagging issues at hand here, Your Honor. My client had hoped wholeheartedly that agreeing to this divorce, coming together, would calm down the difficulties between the parties. And frankly, Your Honor, I'm trying to be as diplomatic as I can, but the defendant is essentially stalking and harassing my client, Your Honor. And it's problematic because, not only is that a problem to begin with, but when we're involving the minor child, it's just horrible. And it's difficult because you say to yourself, okay, how can I help my client? Should she file a personal protection order? What kind of relief can she seek? And it's just been miserable. So I realize, Your Honor, there's just not an objective way to tackle something like, this level of disparagement and harassment. I mean, it's just social media, Facebook, TikTok. It's just an all-out stalking campaign of harassment. And I wish there was a way we could remedy this or put some sort of restraining order that says this conduct can't occur moving forward, Your Honor. And I realize on the real estate, Your Honor, that hey, they relied heavily on the belief that they can move forward on this together, and they just can't because unfortunately, the defendant thinks that he can still come on to my wife or his ex-wife's property whenever he wants. That's just so intrusive to her, and she can't even be comfortable in her own home. And in this property provision where they're stuck with each other until the child graduates is just horrible. So we've laid out, Your Honor, I think a reasonable approach to resolve that issue and put both the parties out of their misery, Your Honor. And in addition to that, Your Honor, I think the rest of what we're asking for is just cleaning up the stuff that needs to be cleaned up that he hasn't done in the judgment, dealing with these titles, just getting these things done that were supposed to be done in the judgment, Your Honor. And I appreciate the opportunity to speak, and I would rely on our motion and ask that you consider all of our relief today, Your Honor. Thank you.
Thank you. The one question I did have is your motion is in essence asking this court to amend a property provision of a judgment, and aren't I prohibited by such cases as Colestock versus Colestock, 135 Michigan Appeal 393, from sticking my nose into what the parties actually resolved, unless they are ambiguous, or there's allegations of fraud, mistake, et cetera, et cetera. Any thoughts on that?
Yes, Your Honor. I mean, that is the law. There's no question. And as I explained to my client, I mean, we are asking for equitable relief here, and I'm making an equitable argument that perhaps the court might consider, having them do this. And the difficulty too, Your Honor, is that Mr. Johnson is not represented by counsel. That there's nothing wrong with that. That's not a negative, but it probably would have been a scenario where I could have contacted an attorney and see if he might be interested in this kind of resolution. But as I've explained to my client, if Mr. Johnson tells the court this morning he's not interested in that resolution, that she will be stuck with this language, Your Honor. That is true.
All right, Mr. Johnson, what say you?
Yes, Your Honor. Well, the accusation of stalking is a gross misrepresentation and over-exaggeration of the truth. The document that was presented to you includes false allegations as well as 2 misquotes. I have no objection to settling the property. I have not been stalking her. I have not been to the house, with the exception of invited to exchanged custody of John. And there was one time where I was invited. I happened to be in town. I live an hour away. I happened to be in town for a dental appointment. And my son contacted me and asked me to come over for 10 minutes to help him with the project in the garage. Again, I have no objection to settling the property. The purpose for us doing that was it was in both of our financial interest. And it was for the best of John to be able to continue to experience both his house and where I'm living now, that what used to be our cottage, to create less stress for him. It was always about him, and it also financially benefited her much more than me. I'm without the equity from the difference in the properties right now. But I absolutely, if she can afford it, would not object to settling the properties.
Okay. Give you the last word, Mr. Cox.
Your Honor, I appreciate the response, and if we could perhaps work out something on the real estate, I'm happy to discuss that with Mr. Johnson at a later time. So I appreciate that. Thank you, Your Honor.
Well, obviously, going down your request for relief on page 5 of your motion, we can start with paragraph A. Mr. Johnson doesn't have a problem with that, so let's do it immediately and get the property taken care of. Same with B. Same with C.
Your Honor, may I make a request?
Sure.
May I request? I like to keep things simple. For the property settlement, if we're going to go into ordering that right now, I would like to, in order to make it simple, I would be willing to relinquish the house to Tiffany if she will relinquish the cottage, the truck, and $100,000 to me.
Well, obviously, as much as I'd like to engage in negotiations on the record, I can't do that. But I would invite you to contact Mr. Cox, who is very good at that, and he can handle that situation. And what's a little disappointing before I get into the rest of it. So A, B, and C are sound like okay, Mr. Cox. So go ahead and put that in your order.
Thank you, Your Honor.
Now, as far as D is concerned, and I'm going to talk to the parties about this because I always have well-intentioned parents that do things to their financial detriment in the hopes that it somewhat blunts the effect that divorces have on kids. Especially, and I'm going to use his initials, JMJ, who's 12. And I think that that's laudable. The problem is when, if some of these things are true, and I don't know if they are or not, because I don't even know either one of you. But what all the good you're doing to try and blunt this can be undone in about 30 seconds via social media, that type of thing. So what I think I'm going to do is, in addition to the things already covered, is I am going to order that the parties enroll for their own protection, in my view, in our family wizard with the tone meter in the next 30 days. That can be done online. It's very simple to do. And that should be how, we'll try it for a year because that's how long the membership goes for. And if it is, if it solves the problem, if parties go, okay, I think we're in a different place, then they can let it expire. Otherwise, I'll review or I'll entertain a request to renew it after the end of a year. I want that done in the next 30 days. Then I want an order. I really don't want to add a personal protection order to this equation. I'm not adverse to it, but I want to try and see if I can resolve it this way first. So let's put in the order that neither party is to enter the premises of the other without the express written permission of the other party. That way everybody's protected. There's nothing left to chance. Your judgment is fairly new, April of 2025. So I'm going to chalk up all this stuff to two people who are trying to figure out how to act and react with one another as a divorced couple and as co-parents. So, but I'm hoping these measures tap that down and that we don't have any more of these incidents. And then we'll see where we go from here. Obviously, you know, we have a robust PPO department. It's available, but I'd rather try this first, Mr. Cox. Is there any question of what I need the order to say?
No, Your Honor. Thank you very much.
Okay. All right. So now you guys have been to court once, post-judgment. Things can either turn around for the better or things can get dramatically worse. And I'm hoping for the latter. I want things to get better between you two because, you know, you both are adults. I know you can handle each other and deal with each other, but your son didn't sign on for this. And I don't want him in the middle of this. And if you don't think he picks up on the stress that's going on between you two, then you don't give him enough credit, because I can tell you when he's 18, he'll let both of you know what he thinks of all of this. But until then, let's keep him out of the picture, please. Thank you both. I wish you the best of luck moving forward, and we're adjourned. Thank you.
Thank you, Your Honor. Have a nice weekend.
Cool.